saying that Mr. Uddhav Thackeray resigned only because he was called upon by the governor to face a trust vote.
I'm grateful. After I had filed a petition, after I had made it sub judice, and after I had said this is completely unknown to law, don't allow it to go on.
And you are frankly accepting the fact that, well, you resigned because the trust vote was going to go against.
When you do an illegal act,
Yeah.
the consequence of that is known to me. Now, just to save time, let me read it. The crux of the issue raised in the petition, where Lordship has got 14A malus, 14A third line. The crux of the issue raised by the petitioner remains that the direction to hold the trust vote was an illegal act because the governor did so by recognizing a faction of 34 legislators. The CM's participation or absence of participation would not dilute that fundamental illegality. If it's illegal, it's illegal. How does my non-participation validate the act of the governor? Is the core question. That's the correct legal answer. In law, since the illegality of 28 was already sub judice, so prior is important, and pending in a court, a participation or absence of participation ex-CM could not possibly affect the prior illegality, which is already sub judice. Now, as an example, if one, this is very important, if one were to assume that I had subjected myself to the trust vote, the ex-CM had subjected himself on 30th and lost, and after losing challenged the trust vote. It would make no difference in law because the trust was merely the consequence of the illegal act of the governor. And the challenge would still relate to the governor's actions and not to the trust vote. D. It is therefore obvious in law, Malas, that the consequence of an illegal act, emphasis on consequence, cannot determine the legality of that act or validate it. Indeed, it could also be said that the petitioners, having challenged the core illegality at the base, namely the governor's actions, without any delay, did not even need to challenge the trust vote. I could have said it's nothing but a consequence. Similarly, if the individual illegal actions are broken up, and there are different petitions, it is clear that for the purpose of legal validity, either the first act of the governor in calling for a protest or the subsequent act of the governor inviting and administering oath, the participation or absence of the ex-CM has no relevance. Now let's just go back up. Let's kindly scroll up on this section. Come to para 3. No, I'm sorry. Para Malas.
So this is the second point. No, Dr.
This is the second point, but just one thing is left here, Malas. Para 9. Para 9. I'm not troubling with A3. My submissions A to N are giving the law EBUs, meaningful, status quo ante, scrambled egg, fait accompli. All that is given with law, Malas. In that, kindly, Malas, do me the favor of treating it as having stated here. Now, Malas, number 10. Indeed, in Bomai, paras, etc. given, the overwhelming majority of 9 judges made it clear that the proclamation under President's rule under 356, there were 2 states involved, Karnataka and Meghalaya, is very important, is liable to be struck down and the dismissed government is fully entitled to be restored to office. But the only reason we are not doing it because elections have happened in the intervening period. Now, just this is very important. This has not been shown to your Lordship. Just give me a minute. 398 and others, 5 judges out of 9 say this. 5. First is Justice Jeevan Reddy with Justice Agarwal. The proclamation must therefore be held to be not warranted by Article 356 outside its purview. Cannot be said that the President was satisfied that the government of the state cannot be carried on. The action was mala fide and unconstitutional. The proclamation is accordingly liable to be struck down. And we would have struck it down, but for the fact that elections have since been held and a new assembly has come in. That's the only exception. Today, the illegal government is running. There is no elections. And the person who otherwise, suppose the Lordship holds the governor to be bad, then a person not entitled to be holding the post of Chief Minister. How can, of all courts, the Supreme Court accept such illegality? If your Lordship's powers are unique in this country, in that even your Lordship's can go beyond the law. Not contrary to law, beyond the law. Then what's the point if the governor's actions are held to be illegal? Actually, your Lordship would be giving a Pyrrhic declaration and accepting that the illegality has borne the fruits of its illegality and people have enjoyed it. Now let's just see next one. In state of Meghalaya, it's very interesting, for the other state in Bomai, para 12 of my note. Again, Justice Reddy said, but for the fact that since the proclamation, fresh elections have been held to the assembly. So suppose Meghalaya had not had elections and Karnataka had, they would have restored in Meghalaya. We would have certainly issued the writ and directed restoration. Justice Sawant for himself and Justice Kuldeep Singh, our conclusions may be summarized. However, in view of the fact that fresh elections have been taken place and new assemblies have been constituted and all, no relief is granted consequent upon the declaration. Therefore, Malas, this is the heart of this point. Now come to Malas, page 1 on 189. The third point is 189. All right. That is coming separately. That's coming separately.
What is the point, Dr. Singhvi?
Yes. Now, well, a very strange argument was raised, de facto doctrine. Regularization and validation by 189. Mr. Salve argued at length. Mr. Mehta also argued, I
Page
believe.
189, I'm sorry to interrupt. What is 189? Dear?
No, page 1.
Page 1 of my note. That is, well, the de facto doctrine that actions validated by the actual act, which is challenged, is illegal. I want to show Malus how wrong this can be and how dangerous it is. Give me just 2 minutes. The case law makes it clear, but just come to the case law later. Just give me 2 minutes. Malus, the first important thing is to note that there are two kinds of challenges. One is a challenge to the very validity of the act. Come to para 8 of my note. I challenge a validity of an act. Let us say the Governor's Act. Let me say competence of a legislation. Let me say fundamental rights. Versus the eligibility of certain people to act under the act, to sit there and act. Your Lordship under 189 protects the second, not the first. If the Governor's action is bad, will 189 ever protect it, Malus? Mr. Malus, my learned friends, two of them argued at great length on 189. Did they answer the question? Ultimately, the core question, my Lord, is just formulated either way, this way or that way. Is the Governor valid or not valid? If your Lordship holds him to be invalid, 189 comes only after your Lordship holds something to be invalid. Otherwise, it doesn't come into play.
189 is said in the context of the vote in the House.
So,
with respect to
exactly. So, therefore, no. 189, your Lordships can and may, and in this case, perhaps should, in the intervening period of 7-8 months, the decisions taken by an otherwise illegally constituted government may be valid under 189. That's the real commonsensical way of implementing it, Balas. I am not suggesting that somebody's appointment is quashed, somebody's transfer is gone, somebody's policy decision.
So what
Maharashtra
you're really
government
saying
made a
is,
liquor policy,
Dr.
therefore
Singhvi,
that
what
is
you're
gone.
saying is that Article 189 recognizes a de facto doctrine.
De facto doctrine.
What the de facto doctrine does is to legitimize the acts of an authority whose original appointment is found to be invalid.
Subsequently found to be
invalid.
Correct.
But that does not validate the original appointment
That's
itself.
that's the one sentence pithy summary. Just give me a minute. Come to D, 8D. 8D. Calling for that goes back to the same thing, Wallace. First act was what? The governor being approached, governor calling. The two others are consequences. Voting is a consequence of the governor's illegal act. So is the oath taking. If the original act is bad and your lordships can't validate it, then this will not validate the vote. Wallace. The consequence is bad. The consequence of an illegal origin cannot validate the illegal origin. And similarly, 189 cannot.
what you're saying is that if the calling of the voting in the House itself is subject
That's
to
just how my lords formulated was right or wrong. Governor's action, A, no basis, and B, if basis, it is wrongly applied, etc.
but that's the affirmation of the House, right? Then what? I mean, I still have it.
Affirmation is coming. That's this section. Bomai dealt with the affirmation.
All right.
Bomai said, we hold something to be illegal. Let's kindly give me a minute. This is very interesting. But thereafter, Parliament has approved it. Exactly the same thing. How can we quash it? Said, no, sorry, will be quashed. Can you come to that now? So first, well, let's come to, yes, I'll just show 50. Just keep 356. Sima's query answered by Bomai. Para 4 of my note, this note. Much worse, fellas. Here there was nothing, in our case there's nothing. There was a presidential proclamation affirmed by Parliament in Bomai. Now come to Wallace para 4. It is respectfully submitted that the said contention is misconceived, liable to be rejected. In Bomai, does my lord have it, Wallace? Para 4. Do my lords have it?
Yes.
Considered the effect of approval of a presidential proclamation by both houses on the legal validity of the proclamation when it is questioned before the Constitutional Court, held a clear majority, 5 judges, Wallace, that if a proclamation on 356 is invalid, the same as liable to be set aside even if it has been subsequently approved by both houses. Your lordship is told 289, 189, this is express approval. This is express approval. Now read this para, very interesting. 110, Justice Sawant for Justice Kuldeep Singh.
We'll check this up. We got the point. I mean, you're saying that the Bombay has a...
Now there is one interesting, very interesting, after 29 years and 2 days, this is happening in a Lordship's court. This para 110, that bold-face line by Justice Sawant says invalid. Lordship got the second line underlined.
Yes.
All the books say it's valid. SCC. SCR correctly says it's invalid. SCC for 29 years and 2 days called it valid.
I hope you're citing our ESCR, Dr. Singhvi.
No. We've checked up. Then they issued a corrigendum. When my learned friend's colleague here, sitting here, pointed it out, then the SCC
Dr.
issued a
Singhvi,
corrigendum.
I must also publicly acknowledge there was a glitch in our ICT infrastructure overnight. My team was working till 5:30 in the morning. They began working yesterday.
Oh, I see.
They left for their homes at 5 o'clock in the morning, 5:30 in the morning, to ensure that we are all
It's very creditable.
we are ICT enabled.
It's very creditable.
And unlike the private sector, they wouldn't get even a rupee worth of bonus or anything. It's just a love for the job that they do it.
The time money.
Private sector is senior education.
Your Lordship is entitled to judicial right.
Batao. You are part of them.
Was.
No, this is just an aside. The
I was
word
saying private sector or senior councils, I said. Chief is saying
some of your lordships, most of your lordships.
I told my learned brother, you are
Stop.
part of them too.
Complete estoppel.
estoppel, that's why I didn't say.
And a very recent estoppel, relatively. Now, the word invalid here is by corrigendum the correct word. It is in the SCC valid. So it can't be valid. Just note that. What is the legal consequence of actions taken by the President if the proclamation is invalid, yet it is approved by both houses? Come to 111 Lordship. See, I am racing only on the underlined portions. The proclamation will not make any difference to the legal status. Express approval. Forget 189. Parliament expressly approves. The action will undoubtedly be illegal. Then we'll skip 10 lines. There is no reason why the Council of Ministers and the Legislative Assembly should not stand restored as a consequence of the invalidation of the proclamation, the same being the normal legal effect of the invalid action. In the context of constitutional provision which we have discussed, and in view of the power of judicial review vested in the court, such a consequence is also a necessary constitutional fallout. Necessary constitutional fallout.
Get the point.
Unless such result is read, the power of judicial review is nugatory and meaningless.
There is a constitutional permissible, it's permissible to have a complete restitution, is what you say.
Otherwise, it's meaningless and nugatory. The 9 judges say that, and next sentence highlighted. Hence, the necessary consequence of the invalidation would be the restoration of the ministry as well as the Legislative Assembly. Then para 114, boldface. Secondly, the court may invalidate the proclamation whether it is approved by Parliament or not. The necessary consequence of the invalidation could be to restore the status quo ante. Therefore, to restore the Council of Ministers and the Legislative Assembly as they stood on the issuance of the proclamation. So if your Lordship is otherwise convinced, your Lordship needs no support than more than a 9-judge bench, which is very clear. No, your Lordship, it may, how it will be made clear, next sentence is very important, next boldface. It is how it will be made clear that the interlocutory relief that may be granted on such challenge to prevent frustration of the constitutional remedy. It is not to prevent the constitutional authority from exercising its powers and discharging its functions. And then to conclude, the court in appropriate cases not will be justified in preventing holding of fresh elections, but will be duty bound to do so by granting suitable interim relief. Then they summarize the conclusions, which I will not read to save time. Clearly, para after para is devoted by Justice Sawant and Justice Kuldeep Singh.
Always very precise.
And just see 7, another phrase, molding of relief, big Roman 7. Otherwise, what's the point your Lordship is exerting so much, if your Lordship comes to that conclusion? With great respect. And that to a court with 141, 142 and special powers. I can understand the High Court possibly flinching. According to me, even the High Court has the power to do it, under your Lordship's judgment. Now, Justice Jeevan Reddy said this, even in case the proclamation is approved, it would be open to the court to restore the state government to its power. If this were not conceded, look at these words, 9 judges, 29 years ago. If this were not the case, the very power of judicial review rendered nugatory, entire exercise meaningless. The court cannot grant the relief flowing from the invalidation. It may well decline to entertain. Well, they say if you can't grant the relief, why did you entertain? That's what this court is saying, 9 judges. How does the Lordship operate both? The 4-step or the 3-step? Then Justice Pandyan, just 2 lines. Above 4A, I find myself in agreement with the opinion of Justice P.B. Sawant on conclusions 1, 2, 4 to 8. This includes my conclusions, Malas, which I just read, 4 to 8. So this is, Malas, the now the second point. 3 points are covered: prohibitory, affirmative, 189, and Malas resignation. I have 3 or 4 answers. Now, Malas, the fourth point is this Malas prospective and retrospective of the EC. They're all important queries which fell from my lord. My lord, the Chief Justice asked this question more than once.
Is not because you have no
That is
case.
C.
That is, Malas, my C. My lord is right. Pages 8 to 10.
On us to
Just Malas,
adjudicate
forget
the
everything else.
entire mind,
I'll take one point here is enough.
decide.
Malas, whatever else your lordship holds, on the bare text, textually and facially, symbol order number 15,
Just
has to be prospective. Malas. Forget all the, we'll come to the
now got
interpretation.
a-
Just read the text facially. That's it, para 15A of my note.
Yes.
Without anything more. We'll come to the consequences. Well, as drafted facially, without any interpretation, it has to be only prospective. Kindly read. Power of the Commission in relation to splinter groups. Now, I've underlined some words. I've taken the liberty of underlining some words. When the Commission is satisfied on information on its possession that there are rival sections or groups of a recognized political party, each of whom claims to be that party, the Commission may, after taking into account all the available facts and circumstances, and hearing such reps of the sections or groups and other persons who desire to be heard, decide that one such rival section or group or none of such rival groups shall be binding. Well, this cannot but be futuro. Factually, there was no need for the ex-CM to submit himself to it. Look at the consequences of holding otherwise. There will be very, very strange consequences. 2 things, if your lordship were to hold the 19th July, that's the date, order of the EC,
Only because he was called upon by the governor to face a trust.
sorry, 17th February 2023, I'm sorry, 17th February. Petition is filed on 19th July. 17th February is the order.
And you have frankly
Now, Malas, the order to be retroactive,
court was going to go
question number 1, retroactive from when? The consequence of that is known to me. Now, just to save time, 3 possibility retrospectivities. Look at the consequence. Well, the lordship doesn't hold it to be without the consequence. 3. One is, it is retroactive from the date the Shivsena was recognized as a 29A political party. That is 1990 or 92. I'm giving you 3 alternatives. I'm not. Because today I am the election commission, I hold that this is the Shivsena. If it is retroactive, logically it should go to the date when 29A. But let's leave that. Second, it goes back to 21st June when this action started. Third, it goes to 19 July when the petition was filed. There are only 3 possibilities. As an example, in all of these, the consequences would be that actually everything I would be guilty, but I am actually, I mean people who have remained with Mr. Thackeray. I'm just using a phrase because there's no other phrase available, and people who have left. Now, the people who have followed the 10th schedule and remained with Mr. Thackeray would be actually liable for disqualification if your lordship relates back that. So your lordship would be giving a premium to those who follow the 10th schedule, and the people who have not followed the 10th schedule, namely the governor's actions, will protect their disqualification also and disqualify me also. I could have said it's nothing but a consequence. Your lordship similarly will not avoid the inevitable consequence by balance. Of course, your lordship's words can always balance, but that's the logical consequence of retroactivity. They would make an arc of immunity for their own disqualification and actually be liable because the party from 19th July, any whip, any order, everything, I have violated because I'm not the party from 19th July. Therefore, I am liable to something. Or from actually, logically speaking, from the origin.
So this is a second.
Therefore, this second point, but just one thing is left here. Para 9. And it would have the strange effect of an election of Mr. Uddhav Thackeray in 2018. Would also go without there being a fresh election unseating him. All that is given with law, in that kindly. Everything will go, no adjudication by the mere act of recognition relating back either to 1990s or to 19th of July or to 23. 21st of June. There would be chaos. The consequences, are liable to be struck down. And apart from the fact that this is clearly textually not what was intended by the symbols order. But the only reason we are not doing it because elections have been happened in the intervening period. The fourth and the last, under this head, I'm not on the next one, under this head, it would also destroy, not collateral damage, major direct damage. It would destroy the relating back which is held by a lordship of Rajendra Rana. Note this well, note this. Not a single judgment even of any high court, leave aside Supreme Court, says that the election commission will relate back. The action was mala fide and unconstitutional. Constitution bench has held the field for very long, saying a disqualification 10 schedule order relates back. But for the fact that election, your lordship, but today to do this, that's the only exception. Your lordship would be giving primacy to an order under a symbols order, with any judicial precedent not saying so, versus a constitutional provision already held by a constitution bench to relate back. And your lordships cannot reconcile a relation back of disqualification with a relation back of the EC. It can't be reconciled. Today, suppose tomorrow the speaker disqualifies Mr. ABC. It is common ground by Rajendra Rana and many other cases. It relates back to June 22. But there cannot be disqualification because by then your lordship also would be applying a EC order retroactively. In state of Meghalaya, it's very interesting. For the other state in Bombay. For your lordship already has jurisprudence and a precedent.
Prospective according to you.
Then the fifth aspect is this political party and legislative party.
Dr. Singh, we now 5 minutes now.
We will finish before lordship's time. Within this time, we'll finish. We are conscious of that. 3:45 minutes, we'll finish within time. I'll give him 5 minutes also. He'll have 5 minutes. Now, F is a very important part. Actually, it goes to the root. This is the political party versus legislative party debate. But from an page 12. Regularization and validation by 189. Mr. Salve argued at length. Members of a legislature party do not have any right to act contrary to the directions of their political party. This is the heart of the political party, legislative party debate, with which Mr. Call also started today at 2 o'clock. As per 194(1), the freedom of speech is subject to the provisions. I pointed it out already. Under 170(1), the assembly of a state consists of members. The members are elected by direct election from territorial constituencies, and the nature of the election process is such that an elected member set up by a political party has no independent identity in the House except as a member of the political party. Well, actually, in practice, how we sit, where we sit, which rooms we are given, is all based on the collectivity of a party. Not an individual. Suppose a member is a leader of a party, he is very, very senior, but that party has only 3 seats. And another party with yesterday's first-time member, but the party is a large number. Seats are allocated, rows are allocated, rooms are allocated only on the basis of party. That's the way it has to be. Now, prior to introduction, this is very, very important. Just kindly see this. This evolution has been forgotten in this argument of political party and legislative party. Prior to the 10 children, prior to 85, the Constitution did not mention political party anywhere. Although in parliamentary democracy, the heart, as your lordship has in the English books, is political party. Westminster model is political party. Even though political parties were always recognized to be an essential component of the Westminster form of parliamentary government, political party as a term was defined for the purpose of election law in para 2H of the symbols order. Thereafter, through amendments, the ROPA, the Representation of People's Act, was put political party. They are the 2 statutory levels. It came in for the first time with the 10th schedule, which is a constitutional recognition of political parties. And today, a lordship has been asked to negate that recognition. Next para. On the other hand, the concept of a legislature party has no legal or statutory basis. A legislature party by its very nature is not a permanent association of persons. Its life is coterminous with the term of the House. The very coming into existence of a legislature party is dependent on a contingency, the success of more than one candidate belonging to a political party. The 10th schedule defines a legislature party in terms of a political party. That is conclusive, I say. According to me, I may be wrong. It's conclusive. Legislature party is defined in terms of the political party. I've quoted the definition. That goes back to the same thing, Malas. And Malas, your lordship is concerned with a whip. The governor being approached. Whip is peculiarly a political party activity. Consequences. Voting is a consequence of the I'm 41. The purpose of defining the group of members of the House belonging to one political party as a legislature party can be gathered from the number of times when legislature party is used. First, in 2.1, it says a member of a house belonging to any political party. What does it mean? Do you have an existence or identity other than the political party? After constitutional amendment and definition? Then, Malas, there is no mention of legislature party in para 2. Governor's action, A, none. Basis, and B, if basis, in para 2, political party is mentioned. Applied, etc. Thus, while referring to individual members, the 10th schedule refers to them as political party to which they belong and not relation to legislature party. The only place in the 10th schedule where the term legislature party is used was either para 3, now gone, or para 4. How can we quash it? In para 3, the term legislature party was used when the faction of 1/3 goes Malas. In para 4 too, it is for merger. Doesn't arise in this case. Doesn't arise in this case. Thus, wherever the 10th schedule provides protection to a group of legislators when acting as a group, it uses the term legislature party. Otherwise, it's described with reference to political party. Now, what is the consequence? This is a little important. The constitutional sequitur of this discussion is that a majority faction legislature party has no constitutional identity except for the purpose of setting up a defense under 4. This is important. Today, there is no status identity of a legislature party except for the defense of merger. That's all. And admittedly, that's not your case. If no defense is claimed, the legislature party has no constitutional or legal relevance is para 43. Therefore, the group of legislators belonging to a political party can have no right of dissent or conscience. This dissent argument. Dissent has to be within the parameters of what 10th schedule allows you. Dissent cannot say that's too broad a basis for your lordships to act or give any judgment on. Dissent. I just say I'm dissenting and I leave the 10th schedule. Very interesting. After 29 years and 2 days. Reliance is placed on the law of speaker, where Deho the Legislative Assembly disqualification rule. The president of the political party was not a member, was given the right to maintain disqualification. Well, this dissent point which your lordship put to me just now also, let me end on that. Just see Justice Venkat in Kyoto. That para has been read one sentence, but read the whole of it. This is directly the point raised in Kyoto. And 2 days called it valid. Your lordship will not be referring to Nawab Your lordship will be reconsidering Kyoto also on this basis. Kindly see. This is a very important para. Para 49 at PDF page 109. Very telling para, directly the same sentiment. How do you harmonize the two? And you cannot allow one to be reduced to vanishing point. Kindly see this. And I'll end in about a minute or 2 minutes.
My team was working till 5:30 in the morning. They began working yesterday.
I see. Indeed, in a sense.
For their homes at 5 o'clock in the morning.
Yeah, read this, fellows. 109. This is very, very important.
We are all,
it's a covered field. Your lordship need not be agonized about it. As my learned friend would like your lordships to raise a new issue before.
Sector, they wouldn't get
it's a covered point.
109
PDF CJ2 CJ1 inappropriate acronym.
You are part of them.
We used to call it CL. One. This is just a aside. Case law one. I don't know where this time. First time I found CJ1. Some of your lordships, most of your lordships.
I told my learned brother, you are part of them too.
Indeed, in a sense, an anti-defection law is a statutory variant of its moral principle and justification underlying the power of recall. What might justify a provision for recall would justify a provision for disqualification for defection. Now, kindly see the exact sentiment which my lords expressed to me. Unprincipled defection is a political and social evil. It is perceived as such by the legislature. People apparently have grown distrustful by the emotive political exaltations that such floor crossings belong to the sacred area of freedom of conscience or of the right to dissent or of intellectual freedom. Can't be put better. The anti-defection law seeks to recognize the practical need to place the proprieties of political and personal conduct, whose awkward erosion and grotesque manifestation, it's grotesque in 92, I don't know how much more grotesque it is now today, especially the 4-step procedure here, whose awkward erosion and grotesque manifestations have been the bane of the times, above certain theoretical assumptions. Theoretical assumption. My learned friends have raised a theoretical argument. which in reality have fallen into a morass of personal and political degradation. We should, we think, defer to this legislative wisdom and perception. The choices in constitutional adjudications quite clearly indicate the need for such deference. Let the end be legitimate. Let it be within the scope of the Constitution, and by all means which are appropriate, which are adopted to that end. And here we have added, I have added 4 clear escape routes or mitigating circumstances. You don't follow them, but you follow this. This is extremely unfair. This is actually, this is again like that technique of giving a notice to the speaker. It is trying to decimate the entire 10th schedule by saying dissent. Dissent has to be within the boundaries. It is not to prevent the constitutional. I'm extremely grateful.
And thank you, Doctor.
Very deeply obliged.
Thank you, Doctor.
And then to conclude, the court in appropriate cases not will be justified in preventing holding of fresh elections.
So I'll finish in 5 minutes.
Duty bound to do so by
The
granting
5 minutes
civil
left.
privilege.
Lords, I have
Then,
put
they
my
summarize
thoughts in
the
rejoinder in
conclusions, which I will not
additional
read.
rejoinder A5,
Clearly,
which is
para
just
after
a
para is
5-6
devoted
page
by
document. I have
justice.
just 5 submissions to make. The Lordships kindly have that.
Just see 7, then other phrase, molding of relief, big Roman 7.
Lords, I had addressed your
Otherwise, what's the
Lordships
point your lordship is
on
exerting
writ
so much
petition
knowledge, your lordship? Counsel them
479 of
great
2022,
respect.
which
And
was
that
a
to court
challenge
with
to the
141,
decision.
142 and
Lord, that is
special powers.
A5.
You
I'm
can
sorry,
understand
ma'am.
the High Court possibly flinching.
Right.
It's rejoinder,
According to
additional
the High Court,
rejoinder
under
A5,
your lordship's judgment. Now,
filed
Justice
yesterday.
Jeevan Reddy said
Yes.
this, even in case the proclamation is approved,
Yes,
it
ma'am.
would be open to the
My
court to
lords,
restore the
I
state
had
government
made
to its
submissions,
powers.
my lord,
If this were not conceded, look at these
only
words.
on writ
9
petition
years,
479,
9 years ago.
which is
If this
challenging
were
the
not the case,
validity of the
very power
decision of the
judicial review
Speaker
rendered nugatory,
on
entire
3rd
excise
of July
meaningless. The court
2022.
cannot grant the relief flowing from the
That is,
invalidation.
my lord, the
It will then
change
decline
of
to entertain. They say,
recognition
if you can't
from
grant the relief,
Sunil
why did
Prabhu
you
to
entertain?
Bharat Gogable
That's what
late
the
in
court
the
is saying, 9
evening of
years.
3rd July. Now, my lords, the
And
validity
then,
of this
Justice
decision
Pandian, just 2 lines.
is, my lords,
About
unconnected
4A. I find myself in agreement
with
with the opinion of Justice
the
Paul
ultimate,
Sawan
my
on
lords,
conclusions
view
1,
which your
2,
lordships
4
will
to 8.
take in the disqualification
This
proceedings,
includes my
whether your lordships
conclusions,
want to
which I have just
decide
read.
it here
4 to 8.
or send it back.
So this is
This, my lords, challenge is an independent
points are
challenge. Your
covered.
lordships will have to
Prohibitory
determine
affirmative,
whether the
189
speaker was
and
right or
constitutional.
wrong. And the only
Now, the
defense
fourth
which was
point
taken
is
originally in the
justice
reply
perspective
was that it is
and
212.
retrospective of the
It is
EC.
inside the house. And I had
All
said that
important
that is
queries have come from my
completely
lord. My lord,
in the
we
realm
cannot
of
question more than once.
unconstitutionality. There has been absolutely no
That is
rebuttal,
C.
my lord. That I have
That is
indicated in
my C,
paragraph
my lord
number
is right.
2, my
It is
lords,
8 to 10.
item 2.
Just forget everything
3,
else.
my
I'll
lords,
take
I had
one
submitted
point here in Shivsena.
sub-Roman
Whatever
small
else the
3,
lordship holds
that
on
the
bare
term
text,
political
textually
party
and facially,
is not an
symbol order
indeterminate,
number 5,
nebulous
EP,
concept.
has to be
Today,
prospective.
there are 30
Forget
people
all the,
claiming,
come to the
there may be
interpretation.
more
Just read the
factions
text.
claiming that I
Facially.
am the
That's at
political
para
party.
15A of my note.
But on 21st of June,
Without anything more.
there was only
Ignore
one
the
political
consequences.
party that
Well,
was,
it
my lord,
has
in
to be drafted
writing, which was
facially,
communicated to the Election
without any
Commission,
interpretation.
that was
It
headed
has
by
to be
us.
only prospective. Kindly read.
Not with
Power of the
respect,
commission in relation to splinter groups.
this is not, my lord, a
99
Narova
that will
Kunjarova.
be
My lordships are
under
aware of
review.
Mahabharat, my lord.
When
That Ashwatthamo Hata,
the commission
Narova
is
Kunjarova.
satisfied
Whether they are Shivsena, we are
intellectual
Shivsena.
possession that there are
In June, my lord,
rival,
still they
that
filed a
there are
petition
rival
on
sections or
19th of
groups of
July.
organized political party,
There was no
each of whom
dispute, there
claims to be
can't be
attacked
any
parties.
dispute in
The
law
commission
that
may,
I represented the
after
political
taking
party.
into account all
So
the
that's the
available facts
second
and
point which has
circumstances,
not been answered as
and
far as section
hearing such
29A
depths
is
of the
concerned. my lord.
sections or groups and other persons who desire to be
Now, my
heard
lords,
decide
Mr.
that
Sibal
one
has
such
pointed
rival
out
section or
about
group or none
the
of such
validity
rival
of the
shall
whip,
be
my lord,
binding.
and that
Well, this
only
cannot but be
the
futuro.
political party can issue a whip.
Number
And that
2,
Erskine and May, all that
look at
was
the
cited.
consequences
And my learned
of
friends
holding
have
such.
argued that
Look at
no,
the
it's the
very, very
legislature
strange
party can issue the whip, Rule 3.1,
Two
etc.
things, fellows.
The lordships have seen
If your
Rule
lordship were
3.1.
to hold
Rule
19th
3.1 does
July
not deal with a whip.
order of the
Neither
EC.
the form deals with a whip. That is by convention.
Sorry, 17
And in
February
fact, affirmed by your
23.
lordship's
Sorry,
judgment
17 February.
in Mayavati.
Petition is
Kindly
filed on
have the
19th July.
highlighted portion, my lord.
17th February
Paragraph
is the order.
73 of Mayavati,
Now, fellows, the
reproduced in
order
paragraph 3
is
here.
retroactive. Question number 1.
Whatever direction is issued by the leader of such legislature party
There are 3
must be
possible
regarded as a
retrospective.
direction issued by the political
Look at
party.
the
This was the
consequence. Whether
argument.
lordship doesn't hold it
There is
without the
no
consequence.
merit in this contention.
One is,
When the
it
provision
is
in the
retroactive from the
constitution
date
has taken
Shivsena
care
was
to make
recognized
a
as
distinction
29A
between the
political party.
legislature party and the original
That is
political
1990.
party, and prescribe that the direction issued
I'm giving you three
should
alternatives,
be
I'm not-
one issued by the
Because
political
today I am the
party
election commission,
or
I
by
hold
any
that
person
this
or
is the
authority
Shivsena,
authorized in this
retroactive
behalf,
logically
there is
goes
no
to
meaning
April
in
29A.
saying that
Let's
whatever
read that.
the leader of the
Second,
legislature party directs
it
must
goes
be
back to
regarded
21st
as that
June
of the original
when the
political
election
party.
started.
This is Mr. Kaul's argument, my lord, specifically rejected.
And third, it goes
Now, my
to
lord, all
19th
this
July when the
parliamentary
petitions were filed.
convention which we have set out in paragraph 4, my lord,
What
has
is the
not been
possibility,
rebutted.
my lord?
Not even
In
one
all of
precedent
these,
shown, my lord.
the consequences would be
Now, my lords, kindly
that,
turn
my
to
lords, actually
Roman 3. And this is a legal
everything
submission, my
I
lord,
would be guilty.
that
I am actually
having a
I
legislative
am
majority ipso
people who have
facto or
remained
ipso jure
with
is not suggestive of a majority in the political party. My lords, Roman 1 and 2 have already been dealt with. Now, my lords, kindly have Roman 3.
and remained with
In fact, my lord, there are one-member legislature parties.
disqualification. If your
And in
relates back
those,
there.
my lord, circumstances and facts, Election Commission
So,
has
Lordship
said
would be giving
that
a
we have
freedom
to
to
see
those
the
who follow the same
organizational
schedule and the people
majority
who have not
to see
followed the
who's
same
the
schedule.
political party. So therefore, my lords, merely
disqualified
saying
also
that you are a
and disqualify me
legislative
also.
majority and therefore you represent the political party is legally incorrect.
Not avoid
Now, my
the
lords,
inevitable
reference was
consequences.
made to
My lords,
Sadiq
of
Ali,
course, your
that Sadiq
words
Ali,
can always
my
be
lords,
contradicted.
affirms this
That's the logical
proposition.
consequence of
In fact, in
retroactive.
Sadiq Ali, my lord, this point was
They
kept
would
open and I have
make an arc
highlighted
of
that, my lord.
annuity for them
Kindly
to
have a
vote
look
this
at Roman
petition
4,
and actually be
the
liable
highlighted
because
portion.
the party from 19th
The
July,
present is not a
any writ,
case
any order, everything, I have violated.
where a
Because I'm
conflict
not the party from 19th
in
July.
the has arisen because of one group
therefore,
having
whereas I'm liable to
majority
something
in the
of
organizational
actually
wing
logically
and
stating
the
what you have
other having a majority in the
Therefore,
legislative
Malas,
wing. This is fallen for consideration here.
And Malas,
Lords, one submission was made by Mr. Jetmalani yesterday that look here, we are also members of the Pratinidhi Sabha. Therefore, we represent the political party. Lords, on affidavits in the election commission and also here, for which there is no rebuttal, out of 220 Pratinidhi Sabha members, 160 plus, my lord, have supported me. 160 plus, not rebutted. Now, my lords, kindly see the next submission which is made. And this is again Mr. Jetmalani's submission. That Quixote said in paragraph 97 that the decision of the speaker is not covered by 212
under this head,
and
the next one, under this
that the rules made under paragraph 8
collateral damage,
have a constitutional status and therefore violation of that 2-day period or 7-day period is violation of the constitutional mandate. Totally against Ravi Nayak, my lord. Not even one judgment was cited in support of that submission, but kindly see Ravi Nayak, it's covered. Now kindly see paragraph 8, my lord, the highlighted portion. The disqualification rules are procedural in nature and any violation of the same would amount to an irregularity in procedure which is immune from judicial scrutiny.
With any judicial precedent not saying so.
I just have 30 seconds, no, I'll just finish now.
Already held by a
My lords, then
relate back.
a reference was made to some speeches, my lord, that I have dealt with. Lord, some speech of some DG is totally inadmissible. My lordships have held it time and again, which your lordships have seen in Kalpana Mehta Constitution Bench and also in Shivraj. Speeches by my lords members totally irrelevant, my lord, to decide what the scope of the provision is.
But there cannot be disqualification.
Then, my lord, para 6, they said that mere non-attendance of a meeting will not amount to a para 2-1A. Specifically, my lord, this was the issue in Shriman Balasaheb Patil. One meeting they didn't attend, it was held to be a para 2-1A, which I have reproduced, my lords, in paragraph 14. Now, the last thing is important.
Dr. Singhvi, now
Kindly
5
have
minutes.
paragraph 15.
We will finish before Lordship's time. Within this time, we'll finish.
Time and again, my learned friends, my lord, said that we have never claimed a split. In fact, I remember, my lord, Honorable Justice Kohli asking Mr. Kaul, is it your case that there is a split? And he said, on more than, my lord's 5 occasions, which I have reproduced, kindly see this. First, our case is not a split at all. I have never argued I have a split. Now, kindly see the submissions before the Election Commission. And now the cat is out of the bag. Please have a look at paragraph 16, my lord, of my note. And I've reproduced paragraph 7 of their petition before the Election Commission. In view of the above mentioned facts and circumstances, it is evident that there is a split in the Shivsena. And all the written submissions filed by Mr. Mahesh Jetmalani and Mr. Shinde, my lords, categorically say there is a split. I have pointed that out, my lords, in paragraph 17. to come here, my lord,
170
and say that we are a faction, we represent the political party, is only sugarcoating, my lord, the factum of a split. Lords, lastly, my lord, ultimately your lordships will decide. Lords, I am reminded of a, my lords,
no independent identity
Sanskrit Subhashit, my lord.
as a member of the political
And it says, my lord, Kakaha Krishnaha, Pikaha Krishnaha. That, my lord, the crow is also black, the cuckoo is also black.
collectivity of a party.
Ko bedaha pika kakoye. What is the difference? Who's the Shivsena here? Vasanta samaye prapte, kakaha kakaha, pikaha pikaha. And I'm sure, my lords, the time of judgment will be clear, my lord, who's the real Shivsena. Thank you so much.
My lord, we'll be failing in our duty if I don't mention that the assisting councils, my lords, on both the sides did a phenomenal job in assisting us. And very grateful to your lordships for all the time.
Our compliments to you for
Yes.
Yes, my lord. Rohit Sharma is here.
our compliments
All on the sides, my lords, they did a phenomenal job. We could not have argued this without their
to
assistance.
the juniors is also.
Yes.
We are
Very grateful, my
very
lords, for all the
patient
time that your lordships gave us. For all the time that your lordships.
We'll
Grateful,
reserve
Lord.
judgment.
Grateful.
Very, very grateful.
Recognized to be an essential component of the Westminster form of parliamentary government. Political party as a term was defined for the purpose of election law in para 2H of the symbols order. Thereafter, through amendments, the ROPA, the Representation of People's Act, was put political party. They are the two statutory levels. It came in Malus for the first time with the 10th schedule, which is a constitutional recognition of political parties. And today, a lordship has been asked to negate that recognition. Next para. On the other hand, the concept of a legislature party has no legal or statutory basis. A legislature party, by its very nature, is not a permanent association of persons. Its life is coterminous with the term of the House. The very coming into existence of a legislature party is dependent on a contingency, the success of more than one candidate belonging to a political party. The 10th schedule defines a legislature party in terms of a political party. That is conclusive, I say. According to me, I may be wrong. It's conclusive. Legislature party is defined in terms of the political party. I've quoted the definition. And Malas, your lordship is concerned with a whip. Whip is peculiarly a political party activity. I'm 41. The purpose of defining the group of members of the House belonging to one political party as a legislature party can be gathered from the number of times when legislature party is used. First, in 2.1, it says a member of a house belonging to any political party. What does it mean? Do you have an existence or identity other than the political party? After constitutional amendment and definition, then Malas, there is no mention of legislature party in para 2. None. In para 2, political party is mentioned. Thus, while referring to individual members, the 10th schedule refers to them as political party to which they belong and not relation to legislature party. The only place in the 10th schedule where the term legislature party is used was either para 3, now gone, or para 4. In para 3, the term legislature party was used when the fraction of 1/3 goes balance. In para 4.2, it is for merger. Doesn't arise in this case. Doesn't arise in this case. Thus, wherever the 10th schedule provides protection to a group of legislators when acting as a group, it uses the term legislature party. Otherwise, it's described with reference to political party. Now, what is the consequence? This is a little important. The constitutional sequitur of this discussion is that a majority faction legislative party has no constitutional identity except for the purpose of setting up a defense under 4. This is important. Today, there is no status identity of a legislature party except for the defense of merger. That's all. And admittedly, that's not your case. If no defense is claimed, the legislature party has no constitutional or legal relevance, is para 43. Therefore, the group of legislators belonging to a political party can have no right of dissent or conscience. This dissent argument, dissent has to be within the parameters of what 10th schedule allows you. Dissent cannot say that's too broad a basis for your lordships to act or give any judgment on. Dissent, I just say I'm dissenting and I leave the 10th schedule. Reliance is placed on the law of speaker, where deho the legislative assembly, disqualification rule, the president of the political party who was not a member was given the right to maintain disqualification. Well, this dissent point which your lordship put to me just now also, let me end on that. Just see Justice Venkat in Kyoto. That para has been read one sentence, but read the whole of it. This is directly the point raised in Kyoto. Your Lordship should not be referring to Nawab Breve, Lordship should be reconsidering Kyoto also on this basis. Now kindly see. This is a very important para, para 49 at PDF page 109. 109. Very telling para, directly the same sentiment. How do you harmonize the two and you cannot allow one to be reduced to vanishing point? Kindly see this. And I'll end in about a minute or 2 minutes. Indeed, in a sense, may I read this, fellows? 109. This is very, very important, fellows. It's a covered field. Your Lordship need not be agonized about it, as my learned friend would like your Lordships to raise a new issue before. It's a covered point.
1090.
109 PDF, CJ2,
CJ1.
CJ1. Inappropriate acronym, fellows. We used to call it CL1, case law 1. I don't know where this time, first time I found CJ1. Indeed, in a sense, an anti-defection law is a statutory variant of its moral principle and justification underlying the power of recall. What might justify a provision for recall would justify a provision for disqualification for defection. Now, kindly see the exact sentiment which my lords expressed to me. Unprincipled defection is a political and social evil. It is perceived as such by the legislature. People apparently have grown distrustful by the emotive political exaltations that such floor crossings belong to the sacred area of freedom of conscience or of the right to dissent or of intellectual freedom. Can't be put better, fellas. The anti-defection law seeks to recognize the practical need to place the proprieties of political and personal conduct, whose awkward erosion and grotesque manifestation, it's grotesque in 92, I don't know how much more grotesque it is now today, especially with the 4-step procedure here, whose awkward erosion and grotesque manifestations have been the bane of the times, above certain theoretical assumptions. Theoretical assumption. My learned friends have raised a theoretical argument, which in reality have fallen into a morass of personal and political degradation. We should, we think, defer to this legislative wisdom and perception. The choices in constitutional adjudications quite clearly indicate the need for such deference. Let the end be legitimate. Let it be within the scope of the Constitution, and by all means which are appropriate, which are adopted to that end. And here we have added, I have added 4 clear escape routes or mitigating circumstances. You don't follow them, but you follow this. This is extremely unfair. This is actually, this is again like that technique of giving a notice to the speaker. It is trying to decimate the entire 10th schedule by saying dissent. Dissent has to be within the boundaries of that. But I'm extremely grateful and
Thank you, Doctor.
very deeply obliged.
Thank you, Doctor. Yes, Mr. Kamat.
So I'll finish in 5 minutes, my lord. The 5 minutes left. Lords, I have put my thoughts in rejoinder in additional rejoinder A5, my lord, which is just a 5-6 page document. I have just 5 submissions to make. The Lordships kindly have that. My lords, I had addressed your Lordships on writ petition 479 of 2022, which was a challenge to the decision. Lord, that is A5. I'm sorry, my lord.
Right.
It's rejoinder, additional rejoinder A5, filed yesterday.
Yes.
Yes, my lord. My lords, I had made submissions, my lord, only on writ petition 479, which is challenging the validity of the decision of the speaker on 3rd of July 2022. That is, my lord, the change of recognition from Sunil Prabhu to Bharat Gogavle late in the evening of 3rd July. Now, my lords, the validity of this decision is, my lords, unconnected with the ultimate, my lords, view which your lordships will take in the disqualification proceedings, whether your lordships want to decide it here or send it back. This, my lords, challenge is an independent challenge. Your lordships will have to determine whether the speaker was right or wrong. And the only defense which was taken originally in the reply was that it is 212. It is inside the house. And I had said that that is completely in the realm of unconstitutionality. There has been absolutely no rebuttal, my lord. That I have indicated in paragraph number 2, my lords, item 2. 3, my lords, I had submitted sub-Roman small 3, that the term political party is not an indeterminate, nebulous concept. Today, there are 30 people claiming, there may be more factions claiming that I am the political party. But on 21st of June, there was only one political
पता नहीं
party
पिछले जन्म में
that
क्या
was,
पाप
my lord,
किएगा
in
हिंदुस्तान में
writing,
पैदा
which was
हुआ। ये कोई देश है, ये
that
कोई
was
सरकार
written.
है, ये कोई लोग है।
Not with
चलो
respect.
छोड़ो, चले जाए कहीं और। दवाइयाँ
Not, my lord, a narrow
पैकिंग अच्छा होता है, दवाई लिखने वाले को भी कुछ मिलता रहता है। आप जानते होंगे डॉक्टरों की कॉन्फ्रेंस
We are Shivsena. In June, my lord, still they filed a petition on 19th of July. There was no dispute, there can't be any dispute in law that I represented the political party. So that's the second point which has not been answered as far as section 29A is concerned. Now, my lords,
साथियों
Mr. Sibbal has pointed out
गांधी जी
about
आपको संबोधित
the
करेंगे।
validity of the whip, my lord, and that only the political party can issue a whip, and that Erskine and May, all that was cited. And my learned friends have argued that no, it's the legislature party can issue the whip, Rule 3.1, etc. Your lordships
Lord, I
have
was
seen
told,
Rule 3.1.
Mr.
Rule
Sibbal,
3.1 does not deal with the whip.
some